San Francisco Bay is listed under the Federal Clean Water Act as impaired for the pollutant dioxin. We brought this case against Pacific Gas and Electric Company because PG&E, like a lot of utilities across the country, uses pentachlorophenol treated utility poles, which bleed toxic gunk onto the ground, which gets picked up by rainwater and carried off into waterways, causing serious environmental contamination issues all throughout Northern California.
Pentachlorophenol is known to be a human carcinogen, and then one of the byproducts of it that ends up in the water supply is dioxin, which is extremely carcinogenic and has shown to be a liver toxin. It's also the active ingredient in Agent Orange, so it's very harmful to plant life.
It's toxic to all kinds of marine life.
And because it is an accumulative toxin, it just tends to spread through the food chain.
When we approach an environmental problem, we look at our toolkit of environmental statutes and try to carefully analyze, well, which of these tools might fit? And even if there's lack of clarity sometimes in the law, we will bring both theories because we need to have a test case. We need to get some rulings on these issues of law. The district court judge ruled just on a legal issue and said that the Clean Water Act preempts the Resource Conservation and Recovery Act, RCRA for short. The anti-duplication clause of RCRA kicks in because the Clean Water Act generally regulates stormwater, even though it doesn't regulate this type of stormwater, and I'm dismissing the case. We thought that this would be reversed on appeal by the Ninth Circuit, which it was unanimously. And so this clarifies that RCRA, as Congress intended, is to be used widely as this landmark piece of legislation that's meant to fill in the interstitial gaps left by the other environmental statutes. The most significant lasting message here is that Ecological Rights Foundation, a relatively small Northern California-based watershed advocacy organization, took on Pacific Gas and Electric Company and fought for 6 years and achieved this result. Now there's 31 PG&E facilities all across Northern California that historically were bleeding pentachlorophenol and dioxin into local watersheds that are going to clean up their act. So it's a big deal accomplishment. And again, shows the power of public interest litigation. Now we'll have an example of not only PG&E doing the right thing, but under federal court order to do the right thing. And hopefully this will be a demonstration that will inspire other utilities to follow PG&E's lead and to take the steps to reduce dioxin loading in watersheds all across the country.